Hi, and welcome to TNR Live. I'm Matt Ford. I'm a staff writer at the New Republic, where I cover law, democracy, and the courts. Thank you for joining us today for the second installment of our three-part Supreme Court Watch series. Throughout the month of June, TNR Supreme Court Watch series will bring you breakdowns and analysis of key opinions and what they mean for our democracy going forward, and for you. Earlier this month, Shelton Whitehouse, senator from Rhode Island, joined us to talk about the court's ethics controversies. Today, we turn to voting rights and the high-profile elections and voting rights cases that the court is hearing this term. Last week, in a surprising 5-4 decision, the court held that Alabama violated Section 2 of the Voting Rights Act by not drawing a second majority Black congressional district. And we're still waiting later on this month for the court's ruling in Moore v. Harper, where the justices will render, perhaps, a decision on the independent state legislature doctrine, which could have a variety of downstream effects for election law cases. Today, we're breaking them down with a fantastic panel of experts. Gilda Daniels is an election law and civil rights professor at the University of Baltimore. She served as deputy chief of the voting rights section at the Department of Justice in the Clinton and Bush administrations. She's the author of Uncounted, The Crisis of Voter Suppression in America. Leslie Prohl leads the voting rights efforts at the Leadership Conference of Civil and Human Rights. She served as the Obama administration and as the director of the Washington office of the NAACP's Legal and Defense Fund. And Carolyn Shapiro is the founder and co-director of the Institute on the Supreme Court of the United States at Chicago Kent College of Law. Her work focuses on the institutions of constitutional democracy and how they interact. She's a former Illinois Solicitor General and has argued many cases in front of the court. First of all, thank you all for joining us today. I'm excited to dive in.
Thanks for having us.
And Gilda, I'll start with you. The Allen v. Milligan ruling earlier last week was described by a surprise by myself earlier and by many in the media. How much of a surprise was it?
It was very interesting that people called it a surprise, and it's astonishing that we are surprised that the Supreme Court followed the law that has existed for almost 40 years. So to call it surprising is somewhat of a misnomer. It should be expected that the Supreme Court would follow the law and follow the precedent. It's almost 40-year precedent. However, we know that in these times it was a bit of a surprise, particularly since during the argument, we were all wondering where could we get a fifth vote from, and for that fifth vote to come from Kavanaugh, as well as Roberts writing the opinion, I think was a bit of a surprise.
And this case involved redistricting in Alabama. It involved the drawing of congressional districts and sort of the apportionment and racial gerrymandering questions. Can you walk us through how the court reached this decision?
Well, it's very interesting. So the court looked at the congressional redistricting in the state of Alabama. There was a lower court decision, which consisted of was more than 200 pages, that looked at the congressional redistricting in Alabama. Alabama had 7 congressional districts. It drew a plan that was very, very similar to its 2011 plan. After the 2020 census, we saw that in the state of Alabama, that 27% of its population was African American. And it drew a plan that was very consistent with the 2011 plan, which did not account for certainly the growth in the Black population. In drawing that plan, it maintained certainly the one majority minority congressional seat in that plan. Senator Bobby Singleton filed a lawsuit in the federal district court, arguing that that plan was malapportioned and that it certainly discriminated against Black Alabamans, and that it should have created two districts. That there were also additional lawsuits filed. One was certainly the Milligan case, Milligan versus Merrill, certainly on the lower court, which again argued that the district, that the plan should include 2 districts, 2 majority minority districts instead of 1, and said that that plan violated Section 2 of the Voting Rights Act, which provides that you cannot discriminate, certainly based on race, and that they argue that this plan certainly should have included an additional district and use certainly Thornburg versus Jingles, which is the 37-year case that has governed how certainly how we handle and how we determine whether or not these districts and other voting rights mechanisms indeed discriminate against people of color. And so the court essentially adhered to the law in Thornburg versus Jingles, which says you have to meet the three preconditions. And certainly the one that certainly got the most discussion was that you had to demonstrate that you could create certainly a district that was composed of primarily minority voters. And so that there was a lot of discussion about that. There was a lot of discussion about algorithms and computer generated plans. But the bottom line is the history of discrimination in Alabama, because the court not only looked at certainly whether or not it could meet the three Jingles preconditions, but also the totality of the circumstances. And so looking at the totality of the circumstances, particularly the history of discrimination in the state of Alabama, as well as its ability to adhere to those conditions which were set in the case law, led the court to arrive at the decision that, which was monumental, right? That Section 2 was constitutional and can be used in redistricting. And another monumental decision is that race can continue to serve as a factor in the districting process. Those were certainly two of the.
I mean, it sort of surprised me because it all didn't really buy that Alabama's arguments made any sense. It seemed like that Alabama's argument, which was, correct me if I'm wrong, but essentially that if they were to remedy what the plaintiffs alleged, that would be in and of itself discrimination. Mm-hmm. It seemed like Robert's the correct reading of it.
I'm sorry, you broke up.
Yeah, you broke up. Were you asking? Oh,
I'm sorry. Yeah, Gilda, I was asking, is it fair to say that Alabama might have overreached here a bit in some of its arguments before the court?
Yes, I think it's definitely a fair assessment. It was amazing certainly to see during the argument that certainly persons like Justice Alito was certainly enthralled with and very engaged in this discussion of algorithms and using computer generated maps. And certainly also one of the things that was wonderful during the hearing was certainly hearing Justice Ketanji Brown Jackson certainly challenge this race neutral idea, right? Because Alabama was forwarding that you should not use race at all. And to use race, they said essentially was discriminatory. And certainly that would have certainly just eliminated the ability to consider race in the redistricting, particularly in consideration of the history that Alabama has, and certainly other states as well. But that was yet another wonderful surprise, if you will, that the Supreme Court outrightly rejected all of those outlandish arguments that would have essentially eliminated the consideration of race in voting cases.
Oh, I'm sorry.
No, I'm done.
No, I apologize. I think that was a transmission error on my end. Leslie, I want to ask you about what the implications are of Kavanaugh's concurring opinion there. He seemed to write one that really sort of downplayed some aspects of the majority rule.
Yeah, I mean, just want to first go along with Gilda's remarks about it being a surprise. You know, I think this was always considered to be a textbook vote dilution case. Alabama had only one minority district since 1992. And as what's happening in many states, there is significant population growth in communities of color. And so as Gilda mentioned, there was a previous attempt to, have another district. And so the time had come for even this 3-judge court. And I think it's important just to note that 2 of the 3 judges in the lower court were actually Trump appointees that basically held that these absolutely, they thought that the map violated the Voting Rights Act and that Black Alabamians were having their vote diluted. I think that should have given us a bit of a signal about just, what the court might do, even though I think many of us were surprised in terms of who wrote the opinion, and we can speak to that a little later when talking about the other voting rights jurisprudence coming from the court, but also that, yes, that Justice Kavanaugh joined the decision, reiterate, it was a very short opinion that he wrote, but very it reiterated several points, but also raised the question that, using kind of race-based methods for addressing discrimination in these types of cases may not be constitutional or proper in perpetuity, in that there some end date for doing this. And so I thought that was one of the more provocative points of his concurrence.
It seemed almost to echo, I'm glad you brought that up because that was one of the things I want to ask about. It seemed almost to echo what they're discussing in another case on affirmative action, that Justice O'Connor referenced in earlier opinion in 2003 on affirmative action college admissions. Do you get the sense that that might be an argument for them to maybe limit the Section 2 in future cases?
I'm among some terrific voting rights experts here, so I will defer to them about whether any justice has ever raised that before. I mean, absolutely, there are, some on the court like Justice Thomas, who has historically raised questions about the constitutionality of Section 2. I can't remember kind of a time-dependent reference to that. So you're right, it does align with Justice O'Connor's question in the affirmative action cases about, do we need race consciousness in higher education? She's 25 years from now. So it does kind of suggest, that type of kind of time-dependent principle. I do think, though, that it's hard to see how that's actually works out in both principle and practice, because you're going to have continued changes in population that legislatures are going to have to respond to redraw maps after every census. And now, it's very clear that they have to comply with Section 2 of the Voting Rights Act. It is as Gilda said, it was a absolute conclusion of this court that it is constitutional, and that yes, race can be used to address race discrimination in redistricting. I don't know that is never not going to be a problem. I hate to be that pessimistic about our society, but I think whatever time frame Justice Kavanaugh was talking about, I don't think it's ever going to go out of necessity that we have to rely on this powerful tool that, has been around since 1965, that was amended in 1982 to specifically add the effects test, and that last week was upheld to be constitutional.
Mm-hmm. What do you think is next for other states? This one focused specifically on Alabama, but other commentators have already drawn in the possibility that it could apply in other states like Louisiana, North Carolina. Where does that sort of go next?
Absolutely. It is going to affect other states. There are a couple of opinions that were on hold, a couple of cases that were on hold, just precisely because the court was considering this question. I just got off another call that I believe there was a report that there are 5 pending matters around the country that directly implicate or are going to have to consider this ruling. I know that the Alabama judges, the 3 judges who initially ruled in this case, called for a status conference after the ruling that I think is going to be held tomorrow. I think they want to hear immediately what the plans are for getting this second district into place to make sure that it is ready for 2024. As Gilda had said, that the Supreme Court had initially suspended or put on hold the 3-judge court ruling. So in fact, the 2022 election occurred under a discriminatory map, a map that had been found to be discriminatory by this 3-judge panel. So it's very important that they right that wrong as soon as possible. I think beyond these 5 cases that there are going to be more consideration about, now that we are sure that the Section 2 vote dilution claims are, how we've been interpreting them for the last 4 decades, how can those be used at the state level with both respect to congressional redistricting, but also state legislative redistricting.
And since we just mentioned North Carolina, I also want to switch gears here a bit and talk to Carolyn about the Moore v. Harper case. I know she's been following it closely. The really strange thing about this case is all the procedural twists and turns it's taken along the way. Carolyn, how do we best understand this case? It's complex both procedurally and doctrinally. What's the best way to look at it as the court's thinking about it?
Well, I think it's important to sort of start with some basic background principles, which is that although we have national elections, under our system, the elections are basically run by the states, and the Congress has the power to regulate aspects of those elections more with respect to federal elections than with respect to state and local elections, but somewhat with respect to all elections, the Voting Rights Act. So there's a kind of complex interplay of federal and state law across the board. But the sort of background principle is that states, and they often delegate to local governments, regulate and run all of our elections. The issue in Moore versus Harper has to do with in Moore versus Harper, it's one specific clause of the Constitution, which says that the time, place, and manner of electing members of Congress is to be determined by the legislature of the state. In each state, it was subject to congressional override. So Congress can pass laws that regulate those elections, and does and has in a variety of different ways. But the language of that clause mentions the word legislature. Now, for pretty much ever, since essentially minutes after the founding, or maybe 3 or 4 years of the founding, we have many examples of legislatures, of state constitutions that limit what legislatures can do when they regulate elections, including federal elections. And we have many examples of state courts saying to state legislatures, hey, the state constitution doesn't allow you to do X, Y, or Z. And then that was the way it was, that the state legislatures were limited, as they are with respect to everything they do, by their own state constitutions, and the state courts could enforce that. The theory at issue in Moore versus Harper picks up that one word legislature and says, actually, nobody knew this, but what that means is that the legislature acts independently, right? That's why this theory is known as the independent state legislature theory. It's not a doctrine. I think you mentioned the word doctrine at the beginning. It's actually not a doctrine because there's no precedent to support it whatsoever. And the court, so the argument is that when state courts say state constitutional provisions limit what the legislatures can do, those state courts are impinging on this special independent power that the federal Constitution has given to state legislatures. That's if you'll pardon the expression, a crazy theory. It's not implausible to look at the words and imagine that the words could have turned out to mean that, but that's not what anybody has ever thought the words meant from the beginning of the Republic. everybody has always understood from the beginning of the Republic, with a couple of really kind of complex and ambiguous moments around the Civil War. Everybody has always agreed that state constitutions apply when state legislatures regulate federal elections, and that state courts, as they do across the board, can evaluate what state legislatures do for constitutionality under the state constitutions. Now, what does all that have to do with North Carolina? What has to do with North Carolina, because North Carolina is an extremely heavily gerrymandered state, but in terms of partisan gerrymandering. It's a purple state. Sometimes statewide it votes for Democrats, sometimes statewide it votes for Republicans. But the legislature and the congressional delegation are overwhelmingly Republican. And they have drawn now 2 cycles in a row incredibly safe maps. And by safe, I mean maps that it's say 10 Republicans and 3 Democrats, or 10 Republicans or 11 Republicans and 3 Democrats, depending on the year, in a state that's basically a 50-50 state. And this is done quite deliberately. This is not happenstance. This is done deliberately. One member of the legislature said at some point that he was supporting drawing 10 Republican districts and 3 Democratic districts because he couldn't figure out how to draw 11 Republican districts and 2 Democratic districts. So that went to the Supreme Court, the US Supreme Court, which said, yeah, that's probably undemocratic. That's not consistent with our principles. But in a 5-4 decision written by the Chief Justice, said we can't do anything about it. Sorry, but the state courts might be able to. So back to the state courts, people went and said, hey, North Carolina, this is unconstitutional under our state constitution. And the North Carolina Supreme Court said, you're right, it is. That's the case that went to the US Supreme Court. So the people who've taken it to the US Supreme Court, who are legislative leaders in North Carolina, want the Supreme Court to say, actually, the North Carolina Supreme Court didn't have the power to do that because, for all the reasons I explained, they say the word legislature somehow creates this rogue entity that's not limited by all the normal bounds and barriers and separation of powers, checks and balances that we have. I haven't gotten to the complicated procedural stuff yet, so I'll pause there in case you want to move on to something else.
Well, no, I mean, that was extremely helpful, and I want to keep on it. I just want to switch slightly to the North Carolina Supreme Court, and they've recently changed tax a bit from what they had previously ruled, and that seems to have thrown a wrench in the entire thing. Can you explain that a bit more?
Yeah. So this is, first of all, this is an advertisement for why everybody should pay attention to elections for judges and justices in their states. If you have elected judges and justices in your states, pay attention. They matter. And here's a very good example of why. The North Carolina, the version of the court, or the makeup of the court that ruled in Moore versus Harper to say that, in fact, this extraordinary gerrymander violated the North Carolina Constitution, was made up of a majority, had a majority of Democratic justices. They are all elected statewide in North Carolina. Subsequently, there was another election, and control of the court flipped, and it is now controlled by a Republican majority. Immediately, the plaintiffs in Moore versus Harper, the legislative leaders in Moore versus Harper asked the Supreme Court the North Carolina Supreme Court to rehear some aspect of the case. The specifics of this actually get so deep in the weeds, I'm not going to go there. But they said, North Carolina Supreme Court, please rehear this case. We're not asking you to disturb what's in front of the US Supreme Court, but please rehear this case. And the North Carolina Supreme Court said yes. Then there was oral argument, briefing, and oral argument, and they issued an opinion in which they said, you know what, we were wrong. In fact, this kind of gerrymander does not violate the North Carolina Constitution. So they completely flipped in the same case after this election. There's lots to say about that, but what's happening in the Supreme Court is there's a big question mark about whether or not the Supreme Court has the authority and the jurisdiction to decide the case under these circumstances. And we could get really nerdy and talk about things like mootness and ripeness and exceptions to mootness and ripeness. And I'm going to spare you and your listeners that, but just to say, it's actually, if you're super law nerd, it's kind of interesting stuff, but nobody really knows what the answer is. So my conclusion from this is that the Supreme Court's going to do what it wants. It's going to decide the case or it's not going to decide the case. And since they haven't dismissed the case yet, my best guess is that they're going to decide the case. My second guess is that there's a minority who want to decide the case and a majority that wants to dismiss, and there's opinions being written explaining those positions. So that's my, you never know what happens at the Supreme Court, but that's I think the basic circumstances we find ourselves in procedurally.
Mm-hmm. And Gilda, if we look ahead 2 years and we think about the next set of elections, I can't believe the next presidential election is just around the corner. Gilda, if we look at that, what would the independent state legislature theory mean on the ground for that? How would that affect things in terms of that, especially after all the chaos we saw in 2020?
Chaos. That's what it would mean, essentially, because if the Supreme Court adopts this independent state legislature theory, and thank you so much, Carolyn, for saying it is not a doctrine, it is indeed one of these, and it certainly was a fringe, what they would call a fringe theory that certainly made it to the Supreme Court. But I think so was the race neutral arguments that they were making in the Allen v. Milligan case as well. So unfortunately, we are seeing that these fringe theories are making their way to the United States Supreme Court. Thankfully, the Supreme Court made the right decision, and certainly a legally consistent decision in Allen v. Milligan, but we don't know what they'll do in this Moore versus Harper case. But if they adopt this independent state legislature theory, that would mean that voters across the country have no judicial remedy in state court or in federal court, certainly to fight partisan gerrymandering. And that impacts certainly the composition of these congressional districts across the country. And the Milligan case was a racial gerrymandering case. This Moore v. Harper is a partisan gerrymandering case. And the Supreme Court, as Carolyn said, the Supreme Court said that they're not in the business of determining whether or not partisan gerrymandering exists or if it violates any constitutional values that we might have. And so that only left the state courts, and certainly left the states for some remedy. So the independent state legislature theory, if adopted by the Supreme Court, would impact certainly not only redistricting, but other decisions that the state legislature makes. It would essentially say that state legislatures can render decisions without any barrier. So this is a checks and balances case, and it could upend certainly the checks and balances that we currently have.
And you mentioned, the Allen v. Milligan case and the racial gerrymandering question. What sort of overlap is there between racial gerrymandering and partisan gerrymandering? How do we tell the two apart?
Well, they often legislatures use race as a proxy for partisanship, right? In many of these states, particularly in southern states, most of the Democrats are people of color. And so what legislatures would say is that they didn't draw the maps in the way that they didn't draw the maps because because the people were Black or brown, right? They drew these maps because they were trying to maximize certainly their partisan hold of a particular legislature. So they drew the maps because they were Democrats, right? They drew them out of the districts because they were Democrats. They're trying to maximize the number of districts that their political party could have. So when you're looking at certainly partisan gerrymandering, the reason they are very similar, Matt, and often it is only a legislature saying, "Oh, we did it because they were a particular party and not because of a particular race." But certainly in bringing those cases, it certainly determines what kind of claims you can bring against in these cases, whether or not it's, you're bringing a case based on Section 2 of the Voting Rights Act, or certainly under the 14th and 15th Amendments, if you're trying to prove, certainly prove discrimination in that way, or you're using some other mechanisms to demonstrate political gerrymandering. It's all, certainly the problem is, it's all to the victim belongs the spoils. This is the way that the court looks at it. Is that if you in these state and local races that Carolyn is certainly emphasizing, and that would certainly help her to emphasize how important these state and local races are, because these are the people who are drawing the maps for your congressional districts, and these are the people who are drawing the maps for your school board, for your city council, and certainly for your state legislature. So all of those are all those things are very important, and certainly we need to keep those in consideration as we move forward. But certainly 2 years from now, we could see complete chaos if there are no barriers, no boundaries for legislatures to comply with in drawing maps.
Can I also add something?
Yeah.
Which is that the version of the independent state legislature theory that's at issue in Moore versus Harper is specific to congressional elections. The version that Donald Trump and some of his advisors tried to leverage in 2020 is a version that says that presidential electors are appointed in the manner that each state's legislature shall determine. That's not a direct quote, but that's basically what it said. So again, the word legislature appears. Yeah. There was a time in our history when in many states, the state legislatures did in fact choose presidential electors. And I don't, and that may or might not be consistent with state constitutions today. And I think there's some pretty good arguments that it's also might not be consistent with the 14th Amendment, but that's a whole other story. But the idea that the door that would be opened if the court doesn't resoundingly reject the ISLT is this idea that somehow the legislatures can if you'll pardon the term, trump the popular vote. Now, under in any version, even if that were accepted, the idea that that could happen after an election, right? The legislature's like, oh, well, we don't like the way it came out. We're just gonna send our own electors. That I do not think works under any theory, because this Constitution also says that Congress sets the date for appointing those electors, and that date is election day. So to say, well, we didn't, we're just not going to pay attention to election day. I don't think that works. But those are the types of arguments that the ISLT opens the door to.
Mm-hmm. And I also, if you don't mind, just wanted to add another wrinkle in that this case, yes, was about partisan gerrymandering, but the kind of argument that legislatures should have all-encompassing power is also very harmful to all our efforts to beat back voter suppression laws. I mean, we're about to mark the 10th anniversary of Shelby County versus Holder on June 25th. And we all have seen the tsunami of laws and practices that have basically come forward after that decision, released jurisdictions with a history of discrimination from having to pre-clear their voting changes before they went into effect. And so state legislatures have been, acting since then to restrict the vote, to, narrow the vote, to roll back early voting. And so those types of practices, if you're giving even more power to the legislature and not allowing state constitutions or state courts, or frankly, federal courts to pull some of that back, that's a whole other ramification of, a bad decision in this case, right as state legislatures are really seeing, we're really seeing them engage in very intense activity to restrict the vote. And until we get pre-clearance back, they're going to keep doing it until there's some, role for the courts or state constitutions to pull that back.
I'm glad you mentioned Shelby County because it segues right into a question from our viewers. Joan from the Wisconsin League of Women Voters asks, and I think it's in reference to his opinion in Shelby County, why did Justice Roberts vote in favor of the VRA in the Alabama case?
So I'll take the first stab at that, and you know the I guess the first answer is no one knows why he did what he did, right? I will posit a guess, and to me, that was the most surprising thing about the case was that John Roberts wrote the decision, and obviously kind of where he is on the spectrum of the court, we probably couldn't win without him. But you know, this is the same Chief Justice who wrote the Shelby decision, really, you know, gutting the heart of the Voting Rights Act, as John Lewis called it, when they suspended preclearance for the jurisdictions with histories of discrimination. That opinion was just a gut-wrenching opinion when it came. I had worked, as many of, I know Gilda was involved in helping Congress reauthorize the Voting Rights Act. That Section 5 preclearance provision was required reauthorization every so often to continue to justify it as a provision under the Voting Rights Act. And there was just, you know, thousands of pages of record evidence submitted to Congress. The Voting Rights Act was reauthorized, you know, 2006, the vote was overwhelming in the House. The Senate vote was 98-0. I was fortunate enough to go to the George Bush Rose Garden ceremony for the signing. It was an incredible, you know, show of bipartisan support that the Voting Rights Act really has had and has enjoyed since its original passage. And so to have an opinion that rejected out of hand that congressional record, and you know, he famously said in his opinion, Justice Roberts did, the country has changed. Yeah. And you know, he did invite Congress to update the formula based on current conditions, but it just was, it was such a democracy destroying opinion, if you will. And then to have him 10 years later author an opinion that upheld Section 2, upheld the constitutionality of the effects test was remarkable. And it's also, I think, very interesting because some of you may know that when John Roberts was nominated to the Supreme Court back in 2000, I can't remember now, 2005, one of the biggest criticisms of his record that the civil rights groups had was that he had, as a young Reagan administration lawyer, written numerous memos against the effects test of the Voting Rights Act that was under consideration by Congress at that time because of a Supreme Court case in 1980 or 81, City of Mobile versus Bolden, that essentially eliminated any type of effects test under Section 2 and basically said you had to have intentional discrimination. There was a huge congressional debate about it. The Reagan administration, through the Attorney General's office and through John Roberts himself, was arguing that it was not constitutional. The Congress ultimately decided on a compromise that John Roberts actually references in the Milligan opinion, that we will have an effects test, but we have to make sure that it's not used to achieve proportional representation. And so it was just remarkable to me that he was citing the own history that he had played a role in back then. And, you know, ultimately the reasons, I mean, we'll go back to what Gilda first said about the case. I mean, it was a slam dunk case based on redistricting principles that had been in effect for decades. And I think just the, at least two of the justices appointed by Republican presidents just thought it was too compelling to try to change the standards at this point, and that the facts were just too powerful. And frankly, that Alabama had overreached in its arguments by asking for absolutely race neutral approach, and also arguing that Section 2 was unconstitutional.
If any of our
Yeah, I think everything Leslie said, I echo. I think there are some other things going on. I mean, I'll start by echoing. Of course, I don't know why Chief Justice Roberts did what he did, but there are some other dynamics at play here. In some ways, this reminds me a little bit of his vote in the Obamacare case, where everybody assumed that Obamacare was going to be struck down. This was in the NFIB versus Sebelius case. He ended up casting the fifth vote to uphold it, and he did it in a somewhat idiosyncratic way, somewhat, by rejecting the Commerce Clause basis, but upholding it under taxing power. But I would say many people think that he did that because, in part, he was very worried about the court as an institution and its political legitimacy, and that to strike down this signature major piece of legislation that President Obama had campaigned on, that had clearly passed under using appropriate procedures, et cetera, would have been could have been really very detrimental to the people's attitudes towards the court. And see Dobbs, right? We have just last spring, the court decides Dobbs, reversing Roe and Casey, eliminating women's guarantee of reproductive and bodily autonomy, and other people's guarantee of that autonomy. And there's been a lot of outcry directed to the Supreme Court's at the Supreme Court. The Supreme Court's approval ratings have plummeted. A lot of people are criticize the court for rejecting precedent without really having a very good explanation for why it was doing so. And I think a lot of similar things could have easily been said if this case had come out the other way. That right, as Leslie and Gilda have both talked about, the law was clear, and there's no new law in this opinion. It's all old law, good law. It's like, but it's reiterating that it's good law. So it could have been another situation where the court was basically overturning 40 years of precedent, similar to what it did in Dobbs. And I think for institutional reasons, the Chief Justice is leery of doing that, or maybe I should say doing that too often.
And if I could just add something, I think Justice Kagan in the oral arguments in Milligan really spoke to what the court would be doing if they had a negative ruling here. She had this moment where she says, I want to step back and ask a question. And that is when this court gutted Section 5 of the Voting Rights Act in Shelby County, it said, oh, Section 5 is just one part of the Voting Rights Act. The meat and potatoes of the Voting Rights Act is really Section 2. In Brnovich versus DNC, which is a decision we haven't really discussed, which came out in 2021, that was a vote denial case coming out of Arizona, and the court really calibrated the standards for proving a vote denial case under Section 2, and dramatically undermined voters' ability to challenge vote denials in Section 2. And Justice Kagan mentioned that case, and she says, so then you have Brnovich, and which was a vote denial case where you undermine the ability of voters to bring vote denial cases. And now, here's a vote dilution case. And, Alabama is asking us to basically, take away the ability to litigate vote dilution cases. And then she kind of leans back and says, so my question is, if that happens, what's left? And it was just this very powerful moment, like, if you do this now in Milligan, you will be wide open to arguments that there is nothing left of the Voting Rights Act except what great lawyers like Gilda and Carolyn can do to, claw back the pieces that were, remaining on the floor with Section 2. But I thought that spoke very, very powerfully to the moment and to the significance of the ruling in this case in particular.
Mhm. And this sort of goes, I'll start with Gilda for this, but this is really a question for all of you. Given what we've discussed today, given the surprise we had last week, how optimistic or pessimistic should people feel about this court right now on voting rights?
Well, on limiting it to voting rights, can I also add another theory for why?
Absolutely.
For why Roberts might have voted, that I've certainly heard, is that they issued the Milligan opinion, because it's so favorable, certainly, to voting rights now, because we're all holding our breath on what they might do in the affirmative action case and certainly in the Moore versus Harper case, to release this good opinion first, and then to say, saying that you can use race, you can have race conscious redistricting, but you can't have race conscious. You can't use race certainly as a factor in education. So I think it's kind of lightening the blow, I guess, with the release of the Milligan case first, as opposed to Moore v. Harper. Now, what was your question again? Because I wanted to make sure. What was your question, Matt? Oh, what can we anticipate for voting rights?
Mm-hmm. Yeah, in general, how is, given what we know about the court's history up until now, given the surprise we had last week, should people be more optimistic, less pessimistic? How should they view the trajectory here?
I don't know if you should be more or less optimistic. I think, again, it was that all the court did was follow the law. And so hopefully that is our expectation, that they will continue to do that. And, while these, theories continue to, rise to the level of, the Supreme Court, hopefully, the way in which the court dismissed the theories in the Milligan case will dissuade others from, continuing to raise these arguments, but we don't even know what Alabama may do. Alabama may continue to say these same things, or certainly, because they're continuing to say things such as, it should be race neutral as opposed to race conscious. So in regards to voting rights before the Supreme Court, again, this case was so clearly a violation of Section 2 of the Voting Rights Act, to the extent that we may have other cases of the same ilk. I think we certainly can anticipate that we might, and hopefully it doesn't even get to the Supreme Court, because the lower courts will adhere to the law and certainly rule consistently with existing precedent. So I don't know if I'm more or less optimistic. I'm just like, I'm relieved is what I am. Everyone was saying they were surprised. I was actually relieved that Section 2 of the Voting Rights Act lives to see another day. Because as Leslie and Carolyn have certainly mentioned, all the cases that have certainly gone for the last 10 years and certainly beyond, there's been a steady stream of disappointments and defeats. So I think, I don't know if I'm not necessarily optimistic, but I am very much relieved.
Can I respond as well? As again, echo Gilda's comments. I'll say and I'll add one other case that we haven't even mentioned yet, which is Abbott versus Perez, a case that was not about the Voting Rights Act, but is actually about equal protection clause and race discrimination in redistricting. And in that case, the which requires an intent, a showing of intentional discrimination, whereas the Voting Rights Act requires not, it requires a lot more than just this, but it's a disparate impact effects test, right? Does this redistricting have the effect of abridging the right to vote on the basis of race? Or the Abbott versus Perez was about intent. And in that case, the court said, in an opinion by Justice Alito, that there was to be a presumption that when a legislature acts, it's acting in good faith, which, makes it, you don't get almost ever a statement on the record like you did in North Carolina about partisan gerrymandering. You don't get that on the record about racial gerrymandering. You don't get on the record somebody saying, well, I want to draw only two majority minority districts, two, because I can't figure out how to draw only one. That doesn't happen. So how are you going to prove intentional discrimination? So there's a whole swath of cases that have come down that have made it increasingly difficult to protect people's voting rights. Additionally, there's the use of the shadow docket, which I think there's some reason for hope that the court is pulling back from. But the way the shadow docket has operated in the last few years with respect to election cases is really been quite damaging. It's made it very difficult for lower federal courts, and in some instances, there's been some warning about lower state courts, remember the ISLT, being able to intervene and say something bad is happening here in the run-up to an election. It needs to stop. So I'm going to say, I'm relieved and delighted about the in Allen versus Milligan. And I mean, I should add, I filed an amicus brief on behalf of members of the Congressional Black Caucus in this case, including Representative Sewell, who's currently the only African-American representative from the state of Alabama. So I'm delighted and relieved, but I don't think we're in good shape if the court is the arbiter of all of these things. That's one of the problems with the ISLT is, although it's called the independent state legislature theory, what it really does is transfer power to the federal courts, and in particular the Supreme Court. And so who needs to act? It's Congress. Congress needs to act. Congress needs to pass much more meaningful voting rights protection. There's the John Lewis Voting Rights Act. There's a whole slew of laws of bills that have been introduced that would really go directly to some of these concerns, and Congress could put in a new preclearance formula. Now, would it be challenged? Of course it would be challenged. But that doesn't mean Congress shouldn't act. And there are some things Congress can do that are really unambiguously within its power. So I would put this, the question of whether or not we should be optimistic about the court is in some ways the wrong question. The right question is, or maybe it's only one of the right questions, right? Another right question is, when is Congress going to protect democracy?
Mm-hmm. And Leslie, if you'd like to wrap us up.
Sure. Well said. Well said, Carolyn. The more the court does, the more imperative Congress has to exert its constitutional role. I would say I am deeply pessimistic about this court and democracy. I mean, if you think about it, I think the Shelby case was such a demonstration of where they are headed. The Section 5 of the Voting Rights Act had been challenged before on several occasions. The constitutionality of it, in each case, it was that argument was rejected. They gutted Section 5 after this incredible record that I spoke about that Congress had developed, and you had this overwhelmingly bipartisan endorsement of it. And then look what the court did. I think that the Brnovich case that I mentioned a couple years ago, Justice Alito wrote that also gives more cause for concern. Again, these were factors that had been recognized for decades about how to prove these cases under Section 2, and the court injected these new guideposts that were supposed to be used to evaluate these claims, and in doing so significantly undermined the ability to bring these cases. The shadow docket absolutely has affected voting cases, and then I would also add another case referred to it as Purcell, which the court basically said if you get too close to an election such that it would mean chaos and confusion for both election administrators and voters, that you cannot have a voting rights ruling too close. And that doctrine or principle that the court announced has been really abused by other courts, lower courts, in holding off remedies and relief for voters when the election is 6 months out. And so, I think the Milligan case is not a sea change. It is a very positive development. It remains to be seen if this is really a change in the direction of the court on democracy. But just given the very recent history of what has happened in these decisions, and frankly, the hostility that some of these justices have shown toward voting and kind of the core essence of the protections of the Voting Rights Act, I have to call me cynical.
And I'll just add, I'm sorry if you're trying to wrap up, but what happened in Milligan, I think we said at the beginning that the court stayed the district court's requirement injunction that Alabama create new districts. So, and as I think Gilda said, that means that the 2022 election was held in Alabama under an illegal, now acknowledged to be illegal, map. And it wasn't just Alabama. Because of what the Supreme Court did when it issued that stay, the judges in Georgia and in Louisiana didn't issue similar injunctions. So given how close the margin is in the House of Representatives, it's possible, it's certainly nothing is a foregone conclusion, but it's possible that shadow docket ruling affected control of the House of Representatives in the last election. So, these are incredibly consequential decisions.
And the last point, Matt, the cases keep coming and the assault continues, but it is certainly freedom fighters like those of us who are here today, and certainly the many lawyers and advocates who are out there. And I think we did not mention certainly the Milligan plaintiffs, the Castor plaintiffs, and the Singleton plaintiffs, who were the courageous people who stood up to say that this needs to be changed. And so we certainly have to recognize the communities and the advocates, and certainly the individuals that continue to fight against these assaults and against voting rights. So we don't have to be optimistic. We just have to continue the struggle, continue to look for victories, and continue to fight and know that we will win.
Well, on that note, I'd like to thank all of you. I'd like to thank Gilda, Leslie, Carol. I especially appreciate it because I know how busy this time of the year is for everyone. And I'd also like to thank you, the audience, for tuning in today. I really appreciate it. As a reminder, the final installment of our Supreme Court series is coming on Thursday, June 29th. We'll be looking at the cases you may have missed during the term, some of the ones that sort of flew under the radar. We'll include today's big decision in Burkine. You can find more details for that and RSVP on our website at tnr.com/events. And you can catch this program and past events on our YouTube channel. I'm Matt Ford. Thank you so much for watching.